I am Morisaki, an actor and the president of the Association of Arts Workers Japan. It is my pleasure to meet you today. As freelance actors, we had no legal protection and were not compensated when we were injured on the job. After lobbying government agencies to improve this, 3 years ago, the workers' compensation insurance system was amended. Thanks to this, arts and entertainment workers' arts are now finally able to obtain a minimum level of social security. It was then necessary for the parties concerned to establish a contact point for enrollment. That is how our association was established. This association is a mutual aid organization, which currently has about 52,000 members, including group members, and is made up of entertainers, actors, musicians, dancers, models, performers, and other arts and entertainment workers from all walks of life, as well as staff members. Today, I would like to talk about the reality of contractual relations from the perspective of arts and entertainment workers. Regarding the proportion of freelancers in the arts and entertainment sector, according to a survey conducted by the Agency for Cultural Affairs 4 years ago, 5.4% of people are employed annually by organizations in the arts and culture sector, so freelancers are considered to be approximately 95% of the total. There is often a misconception that successful arts and entertainment workers are employed, or that arts and entertainment workers who are affiliated with an entertainment agency are employed. Most of this is unfounded. Most arts and entertainment workers are sole traders. 2 years ago, there were reports of a celebrity who committed suicide after losing her job due to the COVID pandemic. We therefore set up a consultation service with clinical psychologists. At that time, we did a survey about the consultation service, and the most common thing people wanted to discuss was contractual issues. This slide shows the results of the Workers' Compensation and Health and Safety Questionnaire. It shows that only 17.8% of the 242 workers have signed a service contract. A survey by the Agency for Cultural Affairs also shows that only 12.7% have a contract in place. This is a clear indication that contracts are not common in this sector. Some of the specific comments that have been made about the lack of contracts include the following. The employing company won't document the contract. I would like to see a government intervention in terms of employment status and health. They use outsourcing agreements to make us work, as much as they want us to work. I want them to make sure that the contract is signed before the work starts. No written contract in many cases. There is no standard for remuneration. There is a tendency to see it as normal for people to pay for their own insurance and other expenses. Not regarded as a working person. Wages not paid. There is nowhere to go for advice. Contracts are lax. I would like to see a contracting system established. Despite taking 3 years to write, only 40,000 yen was paid. There was no payment for copyright fees. When I told them I wanted a contract drawn up, they said there had been no precedent for this in the past. No compensation is provided in the event of an accident. I hit my head and was bleeding, but they didn't pay for my workman's compensation because they only insured the artwork. I want standards to be set so that people don't buy in cheaply. The unit costs remain exactly the same. We need laws to protect freelancers. I would like the contract to be made mandatory as soon as possible. These were among the comments received. When workers' compensation insurance became applicable to arts and entertainment workers, the Ministry of Health, Labor and Welfare defined the insurance coverage as contracted work, and on this occasion the Agency for Cultural Affairs issued guidelines for the establishment of contractual relationships in the field of culture and the arts. I was a member of the study committee that prepared these guidelines, and during the meeting I heard from dancers, musicians, rakugo storytellers, actors, and dancers about the actual situation at a hearing. Here is what I heard at that time. Most of the time there are verbal agreements regarding the exchange of contracts. Many complain about their remuneration. Many people will be asked to lower their prices in one way or another. Changes to the job description do not alter the remuneration. The nature of the work is not clarified at the time the order is placed. There is no room for negotiation because the group is paid according to the performance fee and other terms and conditions made by senior members of the group long ago. You only find out how much you're being paid for the work your manager does between you and them when you're paid. The amount was reduced from what I was originally told, but I couldn't say it because I thought my work was not good enough, so I accepted it without saying anything. The remuneration is not fixed and depends on the ticket sales for the performance. I am not comfortable with the idea of negotiating a sum of money. There is no standard for performance fees. There are organizations where the remuneration is a ticket back and how much for each ticket sold by the performer. In the worst cases, there is a quota, and if you don't reach it, you have to pay for it out of pocket. I am often asked to relinquish or assign my intellectual property rights. We have not received any payment for cancellations in respect of cancellation fees. Often I accept in silence because I am worried that I will have a bad relationship with the client. I have to find my own replacement when I can't perform for reasons on the part of the performer. Regarding the working environment, there are no separate toilets for men and women and no place to change clothes. When I ask about remuneration, I have a fear that I won't get any work in the future. I am worried about what the young people think now. I feel threatened that they will leave soon. It's hard to ask for a written contract because of my position. I would like to see training fees, transport costs, cancellation fees, etc., included in the contract. There's a sort of scam where you only find out that there are a lot of rehearsals and performances after the start of the work. I would like to see a sentence or two about what happens if there is trouble or harassment. In many cases, the order came from the artist. In the US, there were minimum rules in the form of collective agreements between unions and order takers. For example, they would definitely take lunch off. There should first be a negotiation between the client and the worker. I'm worried that if I'm singled out, it will make it harder for me to work in the future. They are not trained to talk to the requester. These are the excerpts. I can relate to all the answers as my own and find it hard. Anyway, you can see that their position is weak. In May last year, one of the responses to a survey we conducted stated that I am having trouble with AI generating my voice. So we conducted a survey on AI literacy and received a huge 26,891 responses in 10 days, with 93.8% of respondents saying they were concerned about rights infringement and other harmful effects. 91.9% of respondents were concerned that they would be used without their permission, 64% that they would lose their rights, 60% that they would lose their skills and motivation respectively, and around 50% that they would lose their jobs or receive less remuneration. 2,612 people claimed to have been victimized by AI. The occupations included illustrators, artists, cartoonists, novelists, musicians, voice actors, models, translators, actors, photographers, game creators, writers, etc. The damage included illustrations, cartoons, animation, voices, faces, texts, novels, translations, etc. being learnt, technology being taken, jobs lost, etc. Of these, 2,099 respondents reported infringements of their rights or intellectual property, moral infringements, being used for child pornography, adult entertainment, etc. 14,500 respondents expressed requests to the government regarding AI, with 5,657 asking for legislation, revision of copyright laws and legal regulations, 3,907 asking for restrictions on commercial use, and 3,907 asking for regulations on a par with those in foreign countries. However, only 2.6% of respondents say they have signed a contract when appearing in music or videos on the Internet, which AI is said to learn automatically. This leaves a situation where there is no written contract to form the basis of any attempt to take countermeasures. To begin with, 78.7% receive little and 78.7% receive zero remuneration from copyright and neighboring rights. Unfortunately, income is very low. Last year, the Ministry of Health, Labour and Welfare's White Paper on the Prevention of Excessive Workers' Deaths found that more than half of the respondents had a household income of less than 4 million Japanese yen. The reality of these households was that more than half were single households. There is also bereavement and separation, but the largest number of households are unmarried. Overall, only 30% of the total number of people are taking 2 full days off a week, excluding voluntary training and tool maintenance. Furthermore, it is highly likely that they are working part-time for a living, so there is a good chance that they are working long hours when their working hours are added up. Contrary to this harsh living situation, 80% of the respondents are well-being and rewarding more than 70% of the time. Serious concerns are that more than half of the respondents suspected depression or anxiety disorders, with 11.6% of those with suspected severe cases. The causes of anxiety include anxiety about whether they will get the next job, 78%, colleagues suddenly stop coming to the site, 66.7%, being told hurtful things at work, power harassment and sexual harassment. Those who have experienced such psychologically taxing events are more likely to have an anxiety disorder. Meanwhile, looking at the situation globally, UNESCO adopted a recommendation on the status of artists in 1980. The recommendation sets out guiding principles for culture, education, and employment, and states that it is necessary to improve social security and taxation conditions for artists, even if they are not employed or self-employed, in terms of policies to provide material and psychological support, and the rights and working conditions that should be granted to them. Ratifying countries have legislated accordingly. For example, Canada has enacted the Artists' Status Guarantee Act, while the Public Social Security has been set up in Germany and other countries. South Korea has enacted the Artists' Welfare Act and the Rights Guarantee Act. In 2012, the Beijing Convention, an international convention for the protection of the intellectual property of audiovisual performers such as film and television actors, was adopted and ratified by Japan, which includes Article 4 on the right of transfer, stating that the performers themselves have rights to reproductions as rights holders and that reproductions must be made with the performer's permission. The World Intellectual Property Organization has stated that the treaty will enable artists to make a living. Meanwhile, the EU Commission created the Freelance Guidelines the year before last. It mainly sets out the approach under the European competition law on collective bargaining and moves in the direction of allowing vulnerable self-employed workers to negotiate, for example by setting remuneration levels and supervising working conditions by electronic means. In Japan, there is hardly any opportunity for freelancers and companies in the entertainment industry to negotiate on an equal footing. In order to solve the problems, it is important to first facilitate better communication between workers and management. Finally, a research book has been published that mainly contains labor law issues on securing payments, setting minimum remuneration and expanding the social security system, which will be necessary in the future. In it I have written about the direction of problem solving in the arts and entertainment arts sector. Although there are some outstanding issues, first of all, we are grateful that this law has been legislated and we, the parties themselves, who are not familiar with the law, have a role to play in upholding the law and improving the working environment. The Japan Fair Trade Commission has already given us a very detailed explanation of the Freelance Act at the study meeting we have organized twice. As a result, the participants have told us that they now know that there is a law in place to protect them, and we are very happy to hear that. We will continue to work hard in cooperation with many other entertainment professionals to ensure a safe and happy entertainment life without anyone being hurt in the future and into the new future. Thank you for your kind attention.